Hello, my name is Deborah Gonzalez, and you're here in the Intellectual Property course for Solo Practice University. Today's session, we're going to be focusing on art and law, or representing artists as clients. A lot of this is going to be based on the beginning concepts of copyright and trademark that we've done in the previous sessions. So if you haven't seen those, I probably would ask you to go and view those first before coming in and listening to this session, okay? As always, we begin with our disclaimer that this presentation is for educational purposes only and really does not constitute legal advice. If you have never represented an artist before, and this can be, we're really talking about the visual arts, not necessarily musicians, that was in another session. Uh, but it can be a little very interesting. They're very interesting clients. They're very creative. They think out of the box, and most of the time they are not thinking about protecting their assets or about the business sense of the word. So, just keep in mind that if you do have an artist as a client, they're going to be, a certain client who's really going to need a lot of hand holding, and you might have to repeat a few things a couple times so that they can understand the importance to them and to the art that they are creating and that they want to let out into the world. So we're going to take a look at the definition of art in terms of, out there in the public marketplace as well as within the law. We're going to look at why artists should protect the art that they're creating, how they can then protect that art, some other legal issues concerning artwork. I also want to touch a little bit on the difference between moral rights, which is the European standard, and then the Visual Artists' Rights Act here in the United States. We'll take a look very briefly at some international legal issues that artists need to be aware of. And then we're also going to take a look at about protecting artists online, especially with all this new digital environment, digital technology, social media platforms, just some things that they need to be looking at to make sure that everything is on the way that it should be. So in your handout, here is this quote that I picked up from Southwestern Law School. And it talks about art knowing no boundaries. And it says, art is a creative endeavor, art as an article of commerce, and art as a significant cultural artifact. And I think this is such an important phrase when we start thinking about representing the artists, because one of the questions that we should always ask our artists when they are our clients is, why do they create the art? What is the message that they are trying to convey with the art that they are producing? Very important, because artists throughout history, they have been the documentarians of history. Think of Goya and the war and his paintings, or they have been the ones to advocate a certain message or a certain cause, or to even bring society, make them aware of some of the issues. So think of the AIDS quilt, or even think of Pablo Picasso and Guernica and some of his other pieces. So it's really important that when we look at art, it's not just the art itself, that 3D image that's been creative, but it's also the reason why that art. So for the artists, it's also very important the process that they went through for their artwork. So just keep that in mind when you're representing your artists. And one of the things is, when you have a client who says, I am an artist, keep in mind that we are not art critics as attorneys, right? We're here to protect their assets. We might not necessarily appreciate the kind of art that the client produces, but in one way, the good thing about the law is that the law is not an art critic either. The law does not decide if art is good or bad. The law does not decide, if this is going to be valuable in the marketplace. I mean, what the law does is basically control how to value the artwork, how the artwork can transfer from one person to another, but it does not necessarily, determine what art is great, what art is not, what art is in good taste or in bad taste. And we have certain, cases that talk about the obscenity of art, or, we have certain cases where individuals have wanted to censor art because they did not feel that it was, up to par to their standards. But the law does not differentiate as to whether it's good art or bad art. It does get involved if it deals with obscenity, and we're going to see that in a little bit, but not right now, okay? And so it's very important just to keep that in mind. Now, why our clients as artists need to protect this? Well, there are some artistic reasons why they want to protect it, including, their creativity. They might be an artist who have developed a new method to doing this kind of artwork, or a new theme in this artwork. Their reputation, for an artist, it's so important that somebody can see their artwork and say, hey, that is X's artwork. I know that kind of painting. I know who did it. Their reputation is everything for them in this marketplace, and it has a lot to do with the kind of value that their artwork will get there. Another reason is for history or a legacy, leaving behind that message that they want to leave behind, okay? Now, there are also, besides those artistic interests, which are very, very important to our clients, there are also the commercial business interests. So, you might have a client who's an artist who does animation or comic books or cartoon shows. And, one of the things with that area is this whole issue of licensing that we're going to see in a few minutes later on in this session. Merchandising, there is a lot of money. If you think of SpongeBob SquarePants, he's on lunch boxes, he's on backpacks, he's on notebooks, pencils, cereal boxes, everything, right? But that's where the money comes in, that merchandising and licensing. But if you do not protect the intellectual property of the artist first, you will not be able to license any of that, because you won't be able to prove that it's actually yours or your clients, that they own it. Marketing is also very important. We're going to talk about trademarks, and a lot of these characters, a lot of this artwork then becomes signature pieces for the artists. They may be the one piece, that symbol that represents the artist. So very, very important to take a look at that. And then, of course, for sales. And, you want to make sure that your client's property interests are protected so that somebody else doesn't come along and copy their artwork and then pass it off as their own, as this can affect both the reputation of the artist as well as their livelihood. And there are lots of contentious cases out there regarding this issue of, who owns what or who came up with it. And remember, as always, we'll see that in a minute with copyright, that ideas are not protectable, right? Okay, so how can all this art be protected? One of the things is a lot of artists, they are not educated about their rights under the law, specifically under the law. They have the feeling, yes, I created it, it's mine, I should be able to protect it, nobody else should make money off of it except for me. But they do not necessarily know the exact laws that apply to this that will protect them. That's why they need us as attorneys to come in and give them that bit of education, okay? But it is important that the artist understands the value of having that legal advisor on their team. And this is something that I usually encourage to my clients, is the idea that, having an attorney is not a bad thing. It could be a very positive addition to the artist's team to be able to make that artist very successful. Okay? So we begin, as always, with the copyright. And what is the copyright? For us in the United States, it is a form of protection. It's grounded, first of all, in our Constitution, and it talks about having to protect original works of authorship. But it does say, besides it having to be original, that it has to be in a fixed format, okay? Now, the law goes on to talk about published and unpublished work, and for artists, that's always a question. Well, what does it mean if my art has been published or non-published? And the answer I usually give to my clients is that it's published if you've made it public, right? And that could be that they put a picture of it on their website. It could be that they, had friends over into their studio and started showing this and exhibiting the artwork. So once it's been made public, even a newspaper article, right? A newspaper that comes in, does a little interview, those community stories about, the artists within the community, just making sure that if that newspaper takes a photo of that artwork, now, it's been published if it's been finished per se. Okay, so just little things to keep in mind. Just what does it mean for it to be published? Now, copyrights are actually a bundle of rights. It's not just one right, but there's 5 distinct rights here. The first one is the right to reproduce the work, the right to copy it. So if your artist has created a painting of a landscape, let's say it's a beach scene, okay, he has a right to then copy that again if he wants to make a whole series of beach scenes. And so, or limited edition of the beach scenes. He can do that. He can make multiple copies of that one image because he was originally his, right? The first one was the original for him, and so he has the right to then make copies of that original that he has done, okay? Nobody else can make a copy of it. Somebody else may make another beach scene. As long as they didn't copy your client's beach scene, then it's fine, right? So if you ever go to the beach, or even if you go to a park, you might see various little artists out there with their easel. They're all painting the same scene, but they're not copying from each other, right? They're painting what they're seeing out there in nature. The second right is the right to create derivative works, and this is very important. This is where that licensing merchandising comes in for our art clients, and it's the idea, right, for derivative works, that if I do that painting, if I have that beach scene, that then I can transfer that and put it on a mug, or I can put it on a t-shirt, right? And then I can sell that. I can make a postcard out of it. All of those are derivative works from that original painting that I had done, okay? I have the right to distribution. Now, this simply means that, you can put the painting up for sale, or you can put it up for exhibit, or you can loan it to a museum or a gallery so that they can then put that up. So being able to give it or sell it, that's that distribution, right, where it goes. A public display right, so important for the exhibits, right? I have the right, if I did that painting or your client did that painting, he or she then has the right to put it up in exhibit and have people view it, put it up for public display. And this also includes whether it's used on a website or even in a film. It's really interesting, film and television now, as part of their props and their set decorations, they may want some artwork, and they may approach your client and say, we'd love to have that piece of art in this show. Well, just keep in mind that that comes under the public display right. And so when you write that contract for the use of it, that you put in that verbiage, that it's a public display right, that in fact your client is licensing to them to be able to use that. Now, it doesn't necessarily mean that there might be some money exchanged. I mean, sometimes the artists, they just want the credit, right? They want to make sure that the film or the television show credits them, that this artwork was done by them, and then maybe even put their website on it. So keep that in mind. That could be a negotiation point as these films and TVs, and it could be even a documentary. It doesn't necessarily have to be a big commercial project. It could be a small indie film. But if they do want to use the artwork, because it's so important for our artist clients to get that exposure, you want to make sure that you put that as part of the contract, okay? And the last is the public performance right. And this is the right to recite, play, dance, act, or show the work at a public place, okay? And showing the artwork, or sometimes we might have art that's combined with poetry in a joint show, or you might have an artist who's doing some video art, right? And so there's a combination of sound and audio and visual to that. So, it always depends on what is the genre of the artwork that our client is actually doing. Now, what does the copyright protect? It protects the original work of authorship. So it could be, so many different things, such as a drawing, a sculpture, a painting, a collage, um, jewelry, video, digital art, photography, even some graphic design can be considered, protectable under the copyright laws. Now, it is important, though, that all of these that I've mentioned are in a fixed mode of expression, right? They're on paper, or they're 3D with the marble and the clay, or a piece of jewelry where you're going to actually be able to touch it and see it, okay, because it's 3D. Again, that is very, very important. If it's just a drawing of an idea of what you're going to do, the drawing is protected as a drawing, but not the ultimate issue. So think of, for example, a sculpture. Sometimes sculptures can be very, very large, and they start off first with being a drawing. That drawing has copyright. Then they start off with a little clay model. That clay model will have copyright in it. And then they have the big sculpture, and that has copyright in it. And that's one of the reasons why there's so much value sometimes in some of these work in progress, those clay models for characters and things like that, that are then used to create characters in a movie. Those clay models actually become collectibles for people who really enjoy the movies and picking up paraphernalia and things of that nature. Okay? Now, according to the copyright laws, copyright is automatic at the moment of creation. And for artists, this also brings up another question. Well, when is my artwork created? When is my artwork finished? Okay, because sometimes artists, it may take them weeks to finish a piece. They might start a piece, they might leave it alone, and go to another piece and then come back to it. And their question is, well, is it protected while it's in progress, right? And so there are different ideas about that, because only the artist can say when the art is finished, when he feels that the art has been completed and then that is done, okay? So you have to talk with the artist about that. Does the artwork have to be registered? Okay, and what does that C in the circle mean? And this is something, again, to talk to your artists about, because some of our artist clients are very prolific. I mean, they are constantly creating, and if you go to their studio, if you go to their home, they have pieces of artwork in different points of progress, and they have them on the walls, they give them out to family, they just have so much. Do they have to register each and every one? Because even though copyright registration is fairly inexpensive at $35, right, if they do it themselves online, if they're that prolific, 100 pieces of art times 35, now you're talking about $3,500. And so it can get, expensive depending on your client and how much art they actually create. Usually what I tell my clients is, are there specific signature pieces, okay? Something that they've created and then they use it as sort of the image every time that they're at a festival or fair, okay? And it'll be put in the program, or if they're at an exhibit and this is the artwork that's going to be shown on the website, okay? So things like that, things that are going to get a lot of exposure in many different avenues, especially in the digital avenues, which can easily then be copied. And why is it important to have this registration? Well, it's very important, and we know this as attorneys, but we do have to explain it to our clients, is that if we do not do the registration within a certain time period, and the law says within 3 months of publication, if we do not register within those 3 months of publication, then our client will lose out on the ability of statutory damages. Now, with copyright, if you find somebody in copyright violation, first of all, in order to get to court, it has to be registered. But secondly, the remedy for our clients is one of two things. The first one is, if they did not register in time, then all they're entitled to is actual profits that were made by the party who was infringing the copyright. Now, the problem is, how do you calculate that, right? And I'll give you an example. I had a client, and they had taken a photograph during an interview of an artist, and then they put that photograph on a t-shirt. Now they had permission from the artist for the photograph, and they assumed that since it was their photographer, they owned the photograph. But remember, there is another right involved in that photograph, and that is the publicity right of that artist himself that was then taken and put on the t-shirt. So his estate sent a cease and desist letter and said, we want to know how much money you made on these t-shirts, and we want an accounting. And so the idea is that whatever money was made in profit, that then the estate of the artist would get that back, because that would be profit, right? And they shouldn't profit from something that they stole or infringed upon. But the issue was, how many t-shirts were sold? 2, and then the maximum each t-shirt was $25 each. So let's say that was $50 in revenue. That's not profit yet. That's just revenue, right? 2 t-shirts times $25, $50 in revenue. But what about the cost of putting it on the website? What about the cost of photographing the t-shirt? What about the cost of promoting the t-shirt? See, all of those are expenses that then are deducted from the revenue. So it's very simple to see how quickly that profit just shrinks down. And sometimes there's not even any profit at all, because all of it went to expenses, especially if it wasn't a very successful infringement and wasn't sold that much, okay? So actual profits, very, very hard, right, to prove. Now, on the other hand, if you've registered within the 3 months, your client can actually claim statutory damages and attorney's fees, meaning that you'll actually get paid. But the statutory damages can be anywhere from $750 to $30,000 an instance, and you don't have to prove actual damages. You don't have to prove actual profits. You just say, I'm within that month, I'm entitled to this statutory damages, okay? And not only that, but if it's proven, if you can prove that the infringement was willful on the part of the infringer, then the court can actually add on another $150,000 if they choose to. So it's just something to keep in mind about that, okay? It's also very important, this idea that it has to be original, and how original is original. So I want to bring up this case to you. It's called Bridgman Art Library versus Corral. It's a 1999 Southern District of New York case. And here, they ruled that an exact photographic copy of a public domain image could not be protected by copyright because the copies lack originality. Now this is really interesting, the way that they are. And they even went on to say that even if the reproduction required a great deal of skill, experience, and effort, the key element is that the copyrighted material must show sufficient originality. Okay, so keep that in mind, that that is really, really important. Okay, now how do we protect some of these copyrights in other countries? Because there is no international copyright. You need to register in each country that you want protection in. There are international treaties and agreements, and in fact, the United States Copyright Office has a wonderful little brochure available online that actually lists all of the treaties and bilateral agreements that the U.S. has by country to protect intellectual property. So if you haven't downloaded that, it's a great thing to have. It's on the U.S. Copyright Office site. There are things there. Also in your handout, you're going to have the link to the European Union Commission that'll take care of this, and the United Nations Educational, Scientific, and Cultural Organization, UNESCO, that does deal with some of this, especially in the cultural heritage side. So there are some artworks that are just considered, traditional, cultural to a specific area and geographic area, and so they do not necessarily are able to get copyright protection for that because it's considered a cultural artifact. So you want to take care of that for all your ethnic artists who might be doing something that's much more traditional and looking at that kind of cultural artwork, okay? Some other things to keep in mind, the concept of the public domain. And here's the idea that the court says, nobody really creates in a vacuum. We need to have inspiration. We all have our muses, but we also just need to have input from all different areas so that then we can create what we want to create, okay? And so because the copyright laws have been revised throughout the years, uh, when an item or a piece of artwork goes into the public domain can be a very difficult calculation. We do have sort of this rule of thumb that says anything that was produced or created before 1923 is now in the public domain. But even with that, you want to check all of those rules and calculations before you just, say yes, it's there and it's public and you can use it without a problem. So you do want to take a look at that. Even though we don't have renewals now, prior to 1976, copyright owners did have to renew. And we are also going through a phase right now where copyrights that have been granted can revert back to the original copyright owner, and we're seeing a lot of those issues with the music. Will we see that in the art world as well? I'm not so sure, but just something to be aware of. Work made for hire. Sometimes the artist clients that we have are actually doing art that they won in a competition to have the commission to do. So this is a lot of public art, for example. Or with graphic designers, for example, they will be requested to create a logo for a company, and they will then transfer that copyright to the company because the company is basically hiring them, a work for hire, to do the logo so that then that company can use it. Okay, so just things to keep in mind. Appropriation, we'll see. I'm just going to put that off for a minute. But fair use. Fair use is that doctrine, right, that doesn't say that copying is not bad. It just says that in this scenario, the copying had a legitimate reason. So, we have those issues of a newspaper doing an art review of the exhibit, for example, and they take a photo of the artwork, and that would be considered fair use, okay, because it's part of that criteria. I want to bring up this case of Prince, and you have the New York Times article that you have here, the link to, so that you can go and look a little bit more about it, talking about appropriation and the idea, can you use pieces of somebody else's artwork in your own work? Well, the laws are always looking at this issue of transformative. If you do something like that, have you transformed it enough so that in reality it doesn't injure the reputation, nor does it affect the livelihood of the original artist? So that's what we're looking at in appropriation. Sometimes also this comes up with our artists who do mixed media, collages, for example, where they go out and they might get tons of magazines and cut pieces out and then make a collage of it and put that up. Now, there we have also the first sale doctrine that goes into place, and it's the idea, okay, you bought the magazines, or the magazines were donated and given to you, and then so you can then do whatever you want with them, right? You can cut them up and you can make it. But you just have to be careful that in no way your appropriation of that is going to injure the livelihood of the original artist, right? Or that would be considered infringing. Okay, now let's just talk a little bit about this idea of standards of obscenity and censorship, because this happens a lot in public art institutions, and it becomes an issue in terms of funding and grants. And you've probably heard the scenario with Rudy Giuliani back when he was mayor of New York, and the Brooklyn Museum of Art putting up an art exhibit where one of the artists had used elephant dung on an image of the Virgin Mary, and Rudy Giuliani was very offended, and he actually cut the funding. And that went to court, and the court said, no, you cannot cut the funding. Again, the law is not going to decipher or decide what's good art, what's bad art. If it's art, it's art. You cannot censor that. That would not be considered obscene. Now, the issue about obscene is that, obscenity is a community standard. Okay, it's what that community accepts as being reasonable versus what it states as being obscene. So the obscenity standard in New York is very different from the obscenity standard in Georgia, different from the obscenity standard in Kansas, different from the obscenity standard in California. And that is not taking into account the different standards that there are in different countries. Okay, so if you have a client who is doing an exhibit in another country, you definitely want to have them review the artwork that they're sending over there, and that they are not going to be in conflict with any of the laws in that particular country, whether it's obscenity or even, for example, in Thailand, where you cannot make any remark against the royalty. You want to make sure that the artwork is not having an offense against the royalty, because not all countries have this freedom of speech, First Amendment rights that we have here in the U.S. So you just want to caution your client with that, okay? Because some countries are very culturally sensitive, so you want to take care of that. Okay, well, I have here a link. This is called Art on Trial, and you have the link right in your handout. And it's really interesting because it just, in short snapshots, it'll talk about some of these cases that have come up in art and law. And I just think it's really, really a great resource to have, something for you to review, as well as something that you can send over to your clients and say, hey, take a look at these, because it's really plain English, so they will understand it. So it's a great, great resource to pass on. Okay. Now, other legal issues when it comes to them exhibiting their artwork, they want to take a look at transportation, okay, because they need to have insurance, and they need to find out, are they going to carry the insurance, or is the gallery, museum, or private collector, or whoever it is that wants their artwork, are they going to carry that insurance? And does the insurance start at the moment that it gets to the carrier, or does it start at the moment that it's delivered? So these are all little things in that contract that you want to take a look for them. You want to make sure that the client can specify on the catalog or program that's being developed for their exhibit what images to show. They might not necessarily want to show all of their images in the program, okay? Especially if they want to sell some of their artwork, because they might feel that, you know, if the person can leave with the program and all the images, they might not actually want to buy, okay? So they want to probably limit the images that they have there. They want to make sure to see if this exhibit or gallery or museum or whoever is going to put any of those images on the website. Okay, again, if you're trying to control the value and not to disperse too many images, you want to find out which images are going to go on the website and which should not. Okay, so it's something to go over with your client about that. Now, one of the other things that comes up in the legal end is that, you know, artists will sometimes get in touch with an art agent, an artist agent, or an artist representative, or an art manager. I have a little scenario, if you go to my website, that talks about the artistic team and what's the difference, for example, between an attorney and a manager, what's the difference between an agent and a representative, so that your clients can understand that. But you know, they should understand right up front that a manager is sort of responsible for helping them develop their career, versus an art representative is more focused on selling artwork. And the other thing is that with art representatives, they might have a portfolio of artists, not necessarily just representing your client or, you know, him and his art, but they might have 20 artists. And so by necessity, they're really concerned about selling art, not necessarily which artist's art they sell. So it's something to have your clients be aware of. Also have your clients be aware of the issues of, you know, how taxes get involved. They are responsible to pay taxes on any money, right? Any income that they generate. So if they sell anything even for $5, according to the law, they are you know, liable for those taxes. And so one thing that you might want to discuss with your client is whether they want to create sort of a corporate entity to protect some of them from personal liability. And it might be as simple as a limited liability company, but it is something for you to discuss with your client about that, okay? One of the things is, lots of times our clients as artists are going to be asked, you know, we have a silent auction, we have a charity, would you mind donating your art? Well, one of the things that they need to know is that when they do that, they can only take as a tax deduction their materials for the artwork. They cannot take a tax deduction on the value of the art or even what it's sold for. They can only take the deduction on their materials. And so one of the other things to sort of encourage and recommend to your artist client is that they talk with a CPA, that they talk with an accountant, and then they understand what these rules are when it comes to their materials and their labor and all of those issues. The other thing that you need to talk to your clients about is about documentation with their artwork, especially if they're selling artwork. They need to keep in mind things like bill of sales, right? Those invoices that they give to the person who buys the artwork and sort of keeps track of that. It will also allow them to keep track of who is actually collecting their artwork and that they can follow up with later on. Authenticity letters, these become very important as well, depending on how renowned your artist is, but it is a good habit to sort of have a letter that goes with a piece of art that states, you know, this art was created by so-and-so, etc., on this date, da 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 da, and have that information there. That's very helpful for the buyers because the buyers are going to take that so that they can then get insurance on the artwork that they have purchased. Okay, so really, really important. I have here on the handout this next little link. It talks, do you keep what you sold, right? Artist heirs win court case over found artwork. And this is something that comes up, and artists don't really think about this too much, but estate planning with their artwork, right? What happens if they were to pass away? Who gets the art? Who's entitled to the copyright in that art? This is really, really important to sit down and have that conversation with your artist, that when they do that will, that they also take into account the artwork that they're creating now and in the future until their death. So, you know, keep that in mind because heirs are entitled to these rights in certain states, and that it can be then inherited on to the next generation. Okay, so we're going to switch gears a little bit, and I want to talk about this issue of moral rights versus the Visual Artists' Rights Act. Now, in Europe and in most of the other places of the world, they have a very strong sense of artist integrity, okay? And that's where the moral rights come in, that an artist retains certain rights to their artwork. And in fact, in some places, there's even a resale value, meaning that if the artist sold it to one person, they get that money, right? But then if that person sells it to another person, the artist gets a percentage of that as well. Very interesting. We do not have that here in the US, but they do have that in some countries over in Europe. But what the moral rights are really saying is that the artist has a right to attribution, right? To say, this is my work, this is my name on it, I signed it. But the artist also has a right to the integrity of the artwork, meaning that nobody can just come and rip it up and destroy it, okay? Unlike in the US, because we have the first sale doctrine that says, hey, this is ours, we can do whatever we want with it, okay? And if I buy the artwork and I want to rip it into little pieces and then make it into a collage on my wall, I can. In Europe, that wouldn't work, but here in the US, it does, and that's why we now have the Visual Artists' Rights Act. Now, this was passed in 1990 under the U.S. Code 17, Section 106A. You have the site right here in your handout. But what's interesting about this, right, is so far it's only really been used in public art. We had one case, and unfortunately these cases have settled, so we don't even have court decisions as to how this is going to go through, but just so that you understand where that is. But it is trying to give the U.S. artists some moral rights here, okay? But we'll have to see where it goes. Basically, it says that you have a right to claim authorship, okay? You have a right to prevent the use of your name on a piece of work that you did not create. Okay, so if you created it, you can put your name, and if you didn't create it, nobody else can put your name on that because you didn't create it, and you have that right to protect your name. Remember, reputation is very important. And you also have the right to prevent the use of your name on a piece of work that has been mutilated, distorted, or modified in any way that would be prejudicial to the author's honor or reputation. So if somebody destroyed it and then put it back together in a way that you as the artist would never, or your client as the artist would never have agreed to, okay, then they have the right to disassociate their name with. And that's what happened in this one case where we had a city council, a monument was made to the Holocaust, and it was rusting, and the city council had wanted to clean it up. And the artist said, no, that was part of my intention. I used these materials because I wanted the rust there. I wanted it as part of the message. And so he sued under the VARA Act. This was settled. We do not have a decision on this, but basically the settlement was he would allow them to clean it up once, and then that's it. Okay, they had to let it rust. So it's just interesting to see how this is going to play out. Even though it was passed in 1990, we really don't have cases that will go one way or another with this. So it's interesting. It's interesting to see where that happens. The international concerns, we did talk a little bit about those resale rights that are there. Keep in mind import and export regulations. And one interesting thing that came up, I had somebody who, is on a work visa in the U.S. and is an artist in his home country and asked, well, can I sell my art here? It's very important to take a look at the immigration laws as to whether they can or not. And technically in the U.S., when I spoke to a colleague of mine who does immigration law, she said, no, he cannot sell them. That would be in violation of his visa. He would have to sell it from his home country. So just, even little things that we wouldn't think has anything to do with this, you can see how that connection was made, okay? Another thing that comes up is the idea of forgeries or hoaxes or art theft. And, these can be international. This is something that, if it is international, might come under Interpol, for example. But something to keep in mind as that goes forward. Make sure that your clients aren't creating forgeries or hoaxes, and make sure that somebody isn't creating a forgery or fraud on your clients. So important to take a look at that. And we have another link to a CNN story that you might want to take a look at there. Okay. Now, online, this is so important because so many artists are going online. They're using websites, they're using third-party websites, they're using social media. Why are they there? Well, lots of times it's so that art lovers can find their art, so art buyers can find their art and actually buy it, so that art collectors can do the same thing and find it, so that art professionals can know about them, get some exposure for it, and so that also they can interact with other artists. So there's many reasons why the artists are out there. And so you have to be careful when your artists want to do that. What are they doing? And one of the most important things to think about in art online is this idea that I always recommend to my clients that they have their own website. Okay, and that if they do have a Facebook fan page, that the Facebook fan page doesn't necessarily have their artwork, but maybe have one or two light images, low resolution, maybe even with a watermark, but then the link back to their website. Because it's their website where they have the most control over. One of the things about these social media platforms like Facebook, MySpace, all of these platforms is that in their terms of services, they do grant themselves, by you signing up, you are granting them an unrestricted worldwide license to use the images or any content that you put up there. And so, you don't have as much control over that once it's up on one of those places, but if it's on your website, you have so much more control, and it really is better. You can put in certain security measures on your website that you just can't do with those platforms, okay? I do have some links here. One of these links, it's really interesting. It's this artist called John Unger, and he had created some fire bowls, and somebody had not only copied them, but then was sort of promoting himself as the one who had created this whole genre of these fire bowls. Now, John had not registered his copyright in time, unfortunately, but not unusual with these types of clients. So he was not entitled to statutory damages, and one of the problems was, well, how does he get money to then sue this person? Because as he said, it was beyond just the principle of the thing. And so he went online and he actually used social media to create a legal fund and to have people donate so that then he can defend himself against this person who was infringed. And he raised about $10,000. He did win the lawsuit. He didn't win any money at all because obviously at that point there was no profit. But he felt good because he was able to defend it. So, it was just an another way that an artist used social media to raise money for them. We do have some art advocacy groups that are online. You have some information there on the handout. And it's interesting because, when we think of art advocacy, don't just think about art education, right? Trying to get art education back into the schools, but it's also about advocating to make sure that federal funds are there for grants and artists, to make sure that censorship isn't done in a way that it's going to infringe on freedom of speech. So art advocacy groups are very, very important, and they are online. And it's good just to let your clients know about them, especially if your client is doing something that's a bit controversial, right? And so he may need some extra protection. It's always good to know that, okay? And we do have some interesting things happening in the museum world when it comes to using social media and art. And as you know, many times museums will say, well, you can't take photographs of certain things. And a lot of that is because, they then use the derivative work right. And they have postcards for sale, mugs to sell, and they don't necessarily want people to take photographs of it. Sometimes a museum might make an exception to that. And I was here in Atlanta, Georgia. The High Museum of Art last year had what they called the High Tweet Up. And they invited people for free to come into the museums. And they said, you can tweet, walk around, tweet what you're seeing, and you can take certain photos. And it was interesting because they gave everybody, when you walked in, you got your name tag so that the security guards knew you were part of the tweet up, right? And so you used your smartphone or your iPad or whatever you had with you. But they gave you a list of photography rules, and basically they said which exhibits you can take photographs in and which ones you couldn't, what you can take photographs of and what you could not. And if you took photographs, please put the artist's name, the year, information like that. So it was really interesting, and they had prizes and stuff like that, but it was a great idea. And people had fun. It was a unique way of that museum sort of engaging with the new digital generation, trying to get that younger generation in. But it was a lot of fun. But they also took care of those photography rules because they had exhibits on loan from other museums that did not want photographs taken. So that was a wonderful, wonderful, good example of putting that legal in and making the digital work as well in the art world. Okay, so you have a link there to show you some information on that. And so I also have here a list of, just some of the things to take a look at online, the legal concerns, and another example that we have there. I want to just bring your attention to this slide that talks about the artist's digital legacy. Now, we had talked about putting it in their wills, right? Well, what about all this stuff that they're leaving online? Make sure that they do have some instructions for that. Now, you don't want to put those instructions in your will per se, because the will becomes a public document after death, right? So you don't want any passwords in the will. You don't want any account information or credentials, ID names, or things like that. But it is something to take a look at. And I have here the link for Facebook and how you can memorialize a page. And this, we're seeing this happen more and more when it comes to artists, that as they pass away, their Facebook page then becomes memorialized by their friends or their family. And it becomes sort of an online virtual gallery for their work and their content and their life. So it's just something, again, to keep in mind. Now, if you have an art client who does a lot of tweeting, they should know that Twitter has donated all of the tweets to the U.S. Library of Congress. Yes, forever and ever and ever, that tweet of your peanut butter sandwich inspiring the latest artwork is going to be there. So they technically do not own them, right? Twitter has now donated them to the Library of Congress. I do have some examples here. I thought they were kind of fun to look at how some of the artists are actually creating art, either using social media as the medium or using social media as the theme, or as both. And so I just brought up some of these creative little side notes that I found online. One of them is the Poet Tweet in New York City, and you have a link there. And here's just an example of one. I'm sorry this poem is a terrible mess, but what can you do in 140 characters or less? And the second one is, if Tolstoy used Twitter to write War and Peace, the hours to read it would surely decrease. And there are tons more. It's a lot of fun to just take a look at them. But again, looking at the artistry of this and the digital aspect. The second one that I bring up is this social cigarettes. This is an LA street artist. Their name is 20, and he makes this statement of Facebook being as addictive as cigarettes, and so he created this life-size, cigarette container, but instead of it being any of the other cigarette marks, it's Facebook, and it has a disclaimer there, and it is a great piece to just take a look at and enjoy, and another one of social commentary. So enjoy that one. I think you'll like the link. Another one that I found is this idea of a Twitter portrait. Buzz, he's Neanderthal, the Netherlands-based company, not Neanderthal, Netherlands-based company, and they create portraits using your Twitter feed about you. So I thought that was interesting to do. And then the other one that I want to bring up is the icon designs. And here this really does address things like with our graphic designer clients. And you see here they have latte art, social icons, so Facebook, Twitter, all in cups of latte. But these can be protected because there is originality there. There's creativity there. It's a fixed medium of format. So, if you have a graphic designer client who creates some of these icons, it can be protected so that they know that. Okay? And so you have some other examples here of some social media art. One which is a performance art, a video on YouTube, and the other one where they actually interact with the participants and the people who go to look at the artwork to be part of that. So, this is a CNN report, social media art brings virtual audiences into cyber galleries. So again, interesting stuff, always good stuff to just share with your clients. They might be looking for more ideas, and they might not realize just, technology can be a godsend, or it can be a problem, or it can be neither and just neutral, but they might want to see some things. Okay. The other thing I want to bring up is something relatively new. Well, not so new, but some artists might not be aware of it yet, and it's called crowdsourcing. You may have heard of places like 99 Designs, for example, or Logo Tournament, where basically these are websites. People go there and say, I want a logo, or I want a website design, or I want an image for, and they sort of give this little description of what they're looking for, what the image should represent, and then it's run sort of like a contest, and different artists will go and submit different items to that contest, and then the client will then go and pick which one they like the best and select that as the winner and pay it. Now, many of these websites, like 99 Designs, will say, well, if you don't like any of them, you don't have to pay for any of them. Or you can guarantee it, meaning that even if you don't pick any of them, whatever amount it was, $250 or $150, $200, that will be split by any of the designers that actually submitted a design. So, something for, again, mainly graphic designers I'm seeing be part of this as another way of income generation and revenue generation. So something for them to take a look at as well. Okay, well, we've covered a lot when it comes to the artists. Always keep in mind, the copyright. I did not talk as much about the trademark, but let's just talk a couple minutes on that and the importance of trademark. There was this thing about, I get a lot of clients who say, well, I sign my portraits. Is that my trademark, right? The signature can become a trademark. It's not necessarily a trademark automatically, okay? And they want to be careful about using their own names as trademarks in case they ever sell the company. We have a case where an artist can no longer use their own name when they create something because it became a trademark, and that trademark got sold when he sold that company. So you do want to be careful about that. But a signature is very important, some way that the artist identifies their work as theirs. And that's basically what a trademark is about, right? It's about identifying a source in commerce and distinguishing that source from all the others. So the idea that your artist, this is their mark, this is their work, it's something for them to take a look at. And if they are going to do any kind of corporate entity, they might want to take a look at that logo and trademarking the logo of that corporate entity that then becomes the signature mark for their artwork, and they can protect that going forward. Okay, so just something to keep in mind. We do have a trademark session, previous sessions, I think it was 2 sessions back. You might want to take a look at that and just see some of those issues and how it can relate to your artist. Well, the resources that I've put here is the U.S. Copyright Office, copyright registration for works of visual art. It's a great little brochure. You can pass on the link to your clients. Art Business is a great little website. It lists some of the legal problems that might be there. The Artists' Rights Society, again, an art advocacy group. Harvard Law School Art IP Rights is another great resource for you if you're just starting to get yourself familiar with some of the cases and art law and some of the facts and concepts in that. It's good for that. And then the Art Law blog. So that's good for you to see there. Well, as always, this is Deborah Gonzalez. I'm glad we spent this time together, and if you have any questions, send them my way. But until then, help your clients keep creating